Good morning, Your Honor.
I'm calling the matter of the City of East Lansing versus Alex Fusco, case number 132921 OD, here today for a hearing on defendant's motion to set aside a conviction. May I please have appearances for the record?
For the record, Your Honor, Kelly Collins, P73222 from Project Clean Slate, on behalf of the defendant, who's also on Zoom. Alex, would you please unmute yourself and state your name for the record?
Good morning, Your Honor. This is Alex Fusco.
Thank you very much. And I can hear you both. Can you both hear and see me and each other?
Yes, Your
Yes.
Honor.
Okay, excellent. So this is a hearing on Mr. Fusco's motion to set aside a conviction. The court has received all of the motion and all the accompanying documents. It has also received a response from the Attorney General's office. Ms. Collins, did you receive that response?
Yes, Your Honor.
Okay, so the court concurs with the Attorney General that it appears that Mr. Fusco is eligible. And so at this hearing, if the court agrees that he meets the statute's eligibility requirements, and also that we determine that his post-conviction behavior warrants a set aside, the court is absolutely able to grant the motion. So with that, Mr. Fusco, what we'll do here is I'm going to administer an oath. I have a few questions to ask you, and then I'll let Ms. Collins ask any questions and make any statements, and you as well. Any questions about the proceeding?
No, Your Honor.
Okay, very good. If you'd please raise your hand, Mr. Fusco. Do you solemnly swear or affirm to tell the truth under penalty of perjury?
I do.
And Mr. Fusco, when this incident happened in 2013, were you operating your motor vehicle in a commercial capacity?
No, Your Honor.
Okay. And was anyone killed or injured as a result of this offense?
No, Your Honor.
And with that, Ms. Collins, I'll turn it over to you for any questioning and further elocution.
Thank you, Your Honor. Just some brief elocution. And for the record, we also have the Michigan State Police report that is dated December 7th, 2025. This is the only case on Mr. Fusco's record, the only time he's ever had any contact with the criminal justice system. He tells me this is a very shameful, embarrassing case. He learned a lot about the risk of drinking and driving and not taking those risks. Since this conviction, he went on to get his Master's in Business Administration, his MBA. He's been working in the auto industry since completing that program. He is now married. He purchased his own home. He's active in his community. He volunteers at the Detroit Boat Club, teaching individuals how to sail. He works with his historical neighborhood association, planning events, doing home tours. So he's active in his community and his neighborhood, but he's hoping to remove this conviction to hopefully not have any barriers as he moves forward in his career. So we believe his circumstances and behavior since this conviction would support the expungement, that it's consistent with the public welfare, and we would ask the court to grant his application.
Thank you so much, Ms. Collins. Mr. Fusco, you heard everything your attorney, Ms. Collins, told me. Well, first, is that all true and accurate?
Yes, it is, Your Honor.
And is there anything additional you would like the court to consider?
No, I just wanted to reiterate what Ms. Collins has said, that it was very shameful. It was a really silly mistake on my part, and it's something I've learned from, and something I wouldn't repeat again. I wouldn't put myself or even like the public at risk engaging in that kind of behavior. So I'm really grateful for this opportunity today.
Okay, well, thank you for that. And if I can, just for my own, edification and to just help understand, it seems like you certainly had this as an experience. It sounds like it was difficult in many ways, but it didn't stop you from becoming the person you wanted to become in terms of your career and your family and your home in your community. So was there anything about this experience, either that was court ordered or not, that helped you move in that positive direction?
Yeah, I think on the behest of my attorney at the time, I did take like a class, and I saw how it had affected people, right? So just seeing that kind of firsthand experience through their eyes, and kind of hearing their stories really impacted me.
That was good. Do you remember who your attorney was?
Oh gosh, I can't remember off the top of my head,
Oh,
actually.
it's
Sorry.
fine. Just curious. And then just my other question would be, did this impact your relationship with alcohol? What is your relationship to
Uh,
alcohol now?
yeah, so now like plan ahead now. If I'm gonna have a night out, I'm going to, make sure either there's a DD or now there's, ride sharing apps and things like that that are, I plan not to drive if I'm ever going to have a drink outside of the home. So, yeah, those two things don't mix anymore in my life.
Mhm. Okay. Well, certainly that bears out in your record before me, Mr. Fusco, and I've listened carefully to your attorney and your statements here today, and I've also reviewed all the documents, and I agree with Ms. Collins that your application is one fully consistent with the statute's requirements, and importantly, the more discretionary determination of the circumstances and your behavior since this offense, does it warrant this grace of expungement? And is that consistent with the public welfare? And I find that it absolutely does. Both of those questions are answered affirmatively. And I think that likely Mr. Fusco is one of the many people that the legislature had in mind when they expanded the ability for people to set aside convictions like this. So I'm very happy to grant your application here today, Mr. Fusco. Ms. Collins, I don't see an order that's been presented. Will you be presenting an order?
Yes, we will submit the
Okay.
proposed order.
Okay, very good. So congratulations, Mr. Fusco. Thank you, Ms. Collins. Anything else for this record, Ms. Collins?
No, Your Honor.
Okay, very good. Thank you.
All right,
Thank
take
you, Your
care.
Honor.
Bye-bye.
Calling the matter of the City of East Lansing versus Michael Chalumba, case number 25899OM. We're here today for an order to show cause, sentencing, and a sentencing. May I please have appearances for the record?
Yes, good morning, Your Honor. Melissa Vachon on behalf of Mr. Michael Chalumba. He's present via Polycom from the Ingham County Jail.
Thank you. And Mr. Chalumba, can you hear and see me and Ms. Vachon?
Yes, ma'am.
Okay, and I'm going to begin, Mr. Chalumba. I have a new order to show cause to advise you of. Mr. Chalumba, it's alleged that you violated the conditions of your bond as follows, that you violated a criminal law of this state on or about February 28th, 2026, as evidenced by 54A District Court case number 574. Mr. Chalumba, as you know, the maximum possible penalty for these violations of your bond is up to 93 days in jail and a fine of up to $7,500. Do you understand the allegation and the possible penalty?
Yes, Your Honor, I understand.
And do you understand you have a right to a lawyer and you have a right to a hearing?
Yes, I do, ma'am.
And Ms. Vachon, how are we proceeding?
Your Honor, we will plead not guilty to that violation. I would ask that the court hold it in abeyance and proceed with sentencing.
And how would that work?
Well, Your Honor, I'm the city attorney was not here, so I wasn't able to talk with him about it. So I would just ask that the court hold it in abeyance so we can proceed with sentencing.
Okay. I mean, just if I'm to sentence Mr. Chalumba, I mean, if I have something pending you can understand why that might impact my sentence and not positive ways for your client. I mean, if I sentence him, I don't, the probation is not recommended, and I don't think anyone here thinks that would be probably a good idea and achieve any goals here. So if he's not on probation, if I don't have jurisdiction over him, how do I have a pending order to show cause? So are you saying that we need to have the city attorney here? Are you asking the court, given the totality of the circumstances, to dismiss this order to show cause? I have other orders to show cause, many that he's pled and admitted to, one of which is from last time he has not been sentenced on. What would you like the court to do?
If I would ask that the court dismiss this new one and we proceed with sentencing on the others.
Okay. And that's, you've talked that over with your client with the understanding that he has admitted responsibility to many other bond violations. And so this is just another bond violation that the court could dismiss given the circumstances and the allegations, but that there certainly are other bond violations that could be, that he can be sentenced on. Is that correct?
Correct, Your Honor.
Okay, so with that, Mr. Chalumba, the court will, and given the interest of justice and your full totality of exposure to the criminal justice system today, will be dismissing this order to show cause, and we will not address it further. So with that, Ms. Vachon, I've received a pre-sentence investigation report, and have you and Mr. Chalumba reviewed that report?
We have, Your Honor.
And do you have any additions, deletions, or corrections?
The only correction I have would be to the jail time. I have his jail count as 15 days as of today.
Okay, and I saw him on the 27th of March. So is you're calculating days that are not on this case, is that right?
I'm counting when he was taken into custody on the 25th of March, and then he was taken into custody for 1 day on the date of this offense as well.
Okay, so on the 25th of March, that was not, he was taken into custody on another case in 54A, correct?
He was, yes.
Okay, so I saw him on the 27th, so that'd be 12 days, and then you're saying there was 1 day upon his arrest, so that's 13 days, is that correct?
Yes.
Okay, very good. So I've made that correction. Any other corrections?
No other corrections, Your Honor.
Okay, and with that, allocution on behalf of your client.
Yes, Your Honor, I just want to begin by acknowledging that Mr. Chalumba knows that his behavior on bond has not been what the court expects of him, and it's not what he expects of himself either. I know that the bond violations are serious concerns here, and he understands that his actions on bond have undermined the court's confidence in him and the probation department's confidence in him. I would ask that the court consider time served here. I don't think that Mr. Chalumba's beyond rehabilitation at all. I think he's going to continue working on himself. However, his new case ends up, he may end up on probation there, but he will continue to work on himself. I think he's certainly learned from his behavior on this night. He was drinking underage with his friends for the first time, and he actually is the one that approached the officers and gave him the fake name. So he understands that that was a poor decision on his part, and he knows it was wrong, and he won't do that again, Your Honor. So I do think he has learned from that and certainly has had time these past few weeks to reflect on his behavior while he's been in custody.
Okay, thank you very much. And Ms. Vachon, just to make a clear record, the pending case in 54A, those are felony cases, which obviously are, more exposure and possibility. If we were going to pursue rehabilitation, those would be cases where there would be more resources to do so. Do you agree?
Yes, Your Honor.
Okay. And Mr. Chalumba, I've listened to what your attorney said. I first just want to make sure, I'm moving on to sentencing right now, and I want to make sure you and Ms. Vachon have discussed, you have a right to be sentenced in person. We're doing this on Zoom. Is that how you want to proceed here today, Mr. Chalumba?
Yes, ma'am.
Okay. And with that, what would you like to tell me before I impose sentence?
I take full responsibility for using the fake name. I was intoxicated, so I wasn't thinking straight. I was just trying to go back home when I was intoxicated, and I'm sorry for that. And I learned my lesson, and I will not give nobody else a fake name.
Okay. Well, I appreciate that, and I take your statements at face value. And I cannot disagree with you, Mr. Chalumba, that in some ways that would be what the court would hope to hear from, someone that's convicted of this charge of providing a false ID. That's not an assaultive offense. It's not, it's something that could just be the product of bad decision making, perhaps bad decision making that was somehow impacted by, your youth and your inexperience, and maybe, some substances that you were experimenting with, and all of those things. So that's certainly an explanation that I can understand and accept here today. The problem, Mr. Chalumba, is not necessarily your underlying behavior that you stand convicted of. It's been your behavior on bond, which, as Ms. Vachon rightly addressed, that is really undermines the court's confidence in well, one, your ability to follow court orders, which that kind of then triggers questions about your respect for the court, your respect for the law, your ability to comport your behavior with what's expected of you. And, it definitely makes it clear, I think, to everyone and to Mr. Bragg, who authored the PSI, that, this is not, you're not a good candidate for probation, at least on this case, because we've had so many problems with compliance. So I wouldn't typically be thinking of a jail sentence, Mr. Chalumba, on offense of this nature, but it's really your non-compliance, your disrespect for the court's orders that is the problem. And that's what's ultimately, I just want to be clear with you, Mr. Chalumba, that's what's going to be that's what's motivating my sentence here. It's not what I accept what you told me about providing that false ID, and I hope that you tell me you're not going to do it again, and I take your word. That's not, we can deal with that, but what we have are just violation after violation of your bond. And then we now have another case, and that whatever is going to happen in that case will happen, but you need to be held to account for your non-compliance with your bond. So for that, Ms. Vachon, I, again, would not disagree with you that a time served sentence could be appropriate just for the underlying case, but with the bond violations, there will be additional jail time that will be imposed for all of the bond violations in his contempt of court. So, Mr. Chalumba, it's a sentence of this court that you shall serve 30 days in the Ingham County Jail with credit for 13 days already time served. And fines and costs are hereby waived because of the jail time. And Mr. Chalumba, you have a right to appeal this sentence. If you wish to appeal, you would file an application for leave to appeal. You can ask for a lawyer to assist you with that application by asking for the lawyer in writing to this court within 14 days. Do you understand your appellate rights, Mr. Chalumba?
Yes, I understand, Your Honor.
Thank you. And anything further from you, Ms. Vachon?
No, Your Honor, if I could just get a breakout room.
Absolutely. That's all for this matter. Good luck.
2 cases, 1 docket, 1 judge, and a lesson about what actually determines where you end up. Alex Fusco made a bad decision in 2013. He got in a car after drinking, was convicted of operating while impaired, and carried that conviction for more than a decade. But he also went back to school. He got his MBA, he got married, he bought a house, he taught sailing at the Detroit Boat Club. He showed up to court today, 12 years later, and asked a judge to recognize that the person who got that conviction is not the person standing before her now, and Judge Greenwalt agreed. Congratulations, Mr. Fusco. Michael Chalumba gave a fake name to police while drinking underage. It is, in isolation, a minor offense, the kind that thousands of young people commit and that most judges would approach with measured patience and an eye toward rehabilitation. Judge Greenwalt was prepared to do exactly that. The problem, as she told him plainly from the bench, was not the fake name. It was everything that happened after. Bond violation, new criminal case, another bond violation. The court's patience is not infinite, and its tolerance for noncompliance has a threshold. Chalumba found it. 30 days in the Ingham County Jail, with credit for 13 he had already served. The difference between these 2 men is not the mistake they made. It is what they did next. One treated a conviction as a reason to be more careful. The other treated a bond as an inconvenience. The court noticed both. It always does. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns. Because justice never gets old.